Hi, this is Dan Smith of DPS Legal Counsel and also the host of the Trademark Counsel podcast. And welcome to today's episode of the podcast. Today, I want to talk about the decision making that you have to go through if you're a small business owner or an entrepreneur who's looking to file for a federal trademark registration, and your trademark is what is called a design mark. And it may be a design mark that has words in it as well, which would make it what is typically called a composite mark. So let's just talk about that. When you look at trademarks, there are two or three different categories of the way a mark looks and appears. One is a standard character mark, which is sometimes called a word mark. And what that is where a trademark is essentially just words. Um, it, it doesn't have a design element to it, doesn't have a logo element to it. It doesn't have, you're not claiming some some rights to a stylized version of the words, like in a certain font or a certain size or a certain color. You're just filing an application for the phrase or words or slogan itself. That is a standard character mark or a word mark. Now, if you have a design, a logo, a picture, an image of some kind, that is a design mark. And often a design mark will have words on it as well. So it's a combination mark. It has words on it, it has a design element to it, and so that would be sometimes called a composite mark because it has both words and a design. Now, when you file for trademark protection and you have a logo or a design that you're using for your trademark, you have to make a decision on the front end how you choose to protect your trademark. You have several choices to make, and it helps when you're making that choice to have trademark counsel, an attorney who works in trademark matters to assist you and to advise you and talk with you about your strategy, your branding strategy, and how you want to protect your trademark. So here, essentially, you have some choices. Let's say you have a mark that has both words in it and a design, and you want to protect that trademark. You could choose just to protect the words and file a standard character mark or a word mark. And if you do that, then you get sort of general. And once it proceeds to registration and you have a registered trademark with those words, you essentially have general protection to keep competitors from filing confusingly similar trademark applications with that would be confusingly similar to your word mark. And that would include both logos that might have those words. It would include just trademarks that were just words. It kind of gives you, and it would include stylized marks, marks with color. It gives you sort of general protection. And for that reason, it's often, in many cases at least, the first thing that trademark applicants would consider when filing for trademark protection is to file for the word mark, because it gives you sort of general protection against a whole host of things, both word marks and design marks that might have the words in them, word marks that are stylized, that have color. Just a general standard character word mark is often, and I would say usually, the first line of defense when you're filing for trademark protection. You could also choose to file a design mark which has your word your word in it, your standard characters in it. Now, when you do that, what you're really doing is applying for the mark itself, which would include both the design and the words, and so you're not just protecting straight out the words themselves. It's the case, however, that if you have a design mark that has words in it, you do have some protection against someone filing just a trademark with just those words, because a trademark examining attorney at the USPTO is going to look at your design mark with the standard character component to it and determine whether or not a word mark that just has words or words similar to yours would be confusingly similar to your mark. So that's an option to consider. I will say, however, though, that typically the strongest or the best strategy in most cases, or in many cases at least, is to file a standard character mark because that's going to be most directly protective of your word or your phrase. These are going to be on a case-by-case basis in a determination of what is the best strategy for any particular business owner or entrepreneur who's filing for trademark protection. But in most cases, a standard character mark is, if you're choosing between the two, is probably a better way to go most of the time. Now, if your budget allows for it, you can file multiple trademark applications and do it something along this line. You can file, let's say you have a logo or a design mark that has words as part of it. You could, and let's say it has color and stylized font as part of it. You could first file, and you can do these at the same time, but these are separate trademark applications. You could file for the standard character mark, the words that are in your mark, number one. Number two, you could file the composite mark, the design that includes the word, as a separate trademark application. And you could do that with respect to, and not claim color as part of it. So if your logo has certain colors in it, you could just do a black and white specimen and not claim color as a part of your trademark. That way you could always choose colors, change your colors without that being part of your trademark application. And third, if you want to claim colors as part of your trademark, if it has certain colors, like for example, there are many companies that color is a big part of their trademark. You could file a separate application and claim the colors that appear in your mark as part of your trademark. That would mean that it would only, with respect to that application, only be protective of your trademark design with those particular colors. So you have a number of options. You can choose to protect across a number of fronts, like by filing separate trademark applications. It all kind of depends on how protective you want to be and what your budget is on your trademark applications. But all of that is part of a determination of what your branding strategy is on the front end. And that's why it makes sense on the front end to have a discussion with your trademark attorney, your trademark counsel, about what is the best branding strategy for you. All right, I hope that helps. That's today's episode of the Trademark Counsel podcast, and we'll see you next time.